The American system of checks and balances is being tested as the federal courts grapple with a tidal wave of cases against the Trump administration's sweeping executive actions. We're also seeing calls for judges' impeachment and labeling court orders illegal when cases don't go the administration's way. So for tonight's interview, we turn to Jeffrey Rosen. He's president and CEO of the National Constitution Center. Jeffrey, thank you for being with us. Can we just start with, it's kind of been lost in this battle over Venezuelan migrants, what Judge Boasberg was initially trying to sort out before it became a fight about did the Justice Department listen to him? What was the constitutional principle he was trying to sort out at first?
The constitutional principle is the president abiding by the law. He's invoked the Alien Enemies Act of 1798. This is only the third time in American history this act has been invoked to deport people who are in the U.S. The other two times involved the War of 1812 and World Wars I and II. So never before has this act been invoked at a time that we're not in a declared war. And the question is, can the president suddenly decide that we're at war not with Venezuela, but with this criminal gang, and then decide that these people are members of the criminal gang without any hearings and deport them? So it's a very serious constitutional question. It may well go up to the Supreme Court. There's serious questions about whether or not the president is acting within the law. And that's what makes it so remarkable that the president has been denouncing Judge Boasberg at this very early stage of the case.
And in his denunciation of Judge Boasberg, he has suggested basically the person who gets the votes makes the decisions. Remind us the relationship between the executive and the judiciary.
Well, the relationship is one of total independence. The foundation of our system of separation of powers is that the president is not a king, and that the president is not above the law, and that the people who ensure that he's not above the law and is not a king are independent judges. And whenever his actions violate the Constitution, those judges have a responsibility to say so. So that's why, at the very founding of our republic, Chief Justice John Marshall thought the entire Constitution and rule of law would be subverted if judges could be impeached because the president disagreed with their rulings. And that's why when Justice Samuel Chase was impeached in 1804, Justice Marshall really worried that his conviction would mark the end of the rule of law. He was so relieved when Chase was acquitted, establishing the principle that judges cannot be impeached because presidents disagree with their rulings. And that's why Chief Justice John Roberts the other day was correct to say that for more than 200 years, there's been a bipartisan principle that you don't impeach judges because you disagree with them. That's how seriously the stakes of this dispute are.
Jeffrey, there is also supposed to be in the three branches ambition fighting ambition. Where is Congress in this conversation? Are they being ambitious in the way that the founders thought?
You're so right to quote James Madison in the Federalist Papers on ambition clashing with ambition. And it's arguable that Congress is not performing the constitutional role that the framers thought. James Madison thought Congress would be the most dangerous branch, sucking all powers into its impetuous vortex, as he memorably said. And the framers believed that Congress would vigorously assert its own constitutional prerogatives against a far weaker and more constrained executive as overseen by judges. Congress, for really decades, this is not a function of the Trump administration, has delegated vast swaths of power to the president, including over immigration. And the combination of congressional acquiescence and a deferential judiciary has allowed the president to consolidate and accrete power in ways that some of the founders feared.